we're indeed very, very excited. After this morning, I don't know, I think to that excitement is now added apprehension. Ignorance is blissful, and now I'm not sure that it's a blessing, Edgar, but we are indeed very excited, and it's hard to imagine a more exciting time in the plant variety protection world in the US, because several years ago, I remember we were all worried about are we going to continue to get applications, and then all of a sudden between the asexual amendment and hemp, which my colleague from PTO will cover a little more, we may get too good a thing happening, all of a sudden too many applications. So hopefully you're right that we'll get quite a few applications. Just a quick note about the Agricultural Marketing Service Science and Technology Program. We have 4 divisions here. 2 of them deal with seed. I think last year, our other excitement is the addition of the seed regulatory and testing division to the Science and Technology Program, which makes the program the single interface with the seed industry for seed-related issues. The Seed Regulatory and Testing Division administers the Federal Seed Act, which regulates interstate commerce of seed, and also administers on behalf of US the OECD seed scheme in the US. So in addition to UPOF learning, I now have the task of learning more about OECD. And of course, the Plant Variety Protection Office is the most exciting part of my job. Although I'm not a breeder nor a plant examiner, it is truly the most exciting part of our program. Currently in the US, and this is prior to the 2018 Farm Bill amendment, we have 3 types of protection for plant variety, plants. So basically, for the agriculture part, you have for seed and tuber propagated variety plants, and then the USPTO, you have plant patents and utility patents. So as of last December, of course, the Farm Bill amendment gives us a 4th type of protection, which is for the agriculture, the PVP. We now have protection for asexually propagated varieties. So what do we need to do to make this happen? So we have the law changed, and of course we have to go through the pleasure of having our regulations changed, which in itself is a task. It's under the best of circumstances. It takes a good part of 2 years, I think, to get this done. Fortunately, because it's a Farm Bill amendment, we do have an expedited process in the sense that there is a deadline. So we have to get it done before the anniversary of the amendment, which is December. So our office currently has a draft proposed rule, which is going through our Office of General Counsel review. After that, it will start the department clearance to get the proposed rule published for 60 days for comments. Upon the conclusion of that, of course, we will be reviewing the comments, we will be writing the final rule. Hopefully that process won't be too long and we can still get it done, definitely before the deadline, hopefully before that. And when the final rule is published, our office will be able to start accepting applications. So quickly, the timeline, the deadline is December the 20th, 2019, and our goal is to get it published by this September because our fiscal year starts October the 1st, and it's great to be able to start accepting applications as of October 1st. So that's a very, very optimistic goal, but it may happen. Currently, we're working on germplasm depository requirements and guidelines. In the US, there's a strong tradition of open access, so that's part of our IP protection principle that we need to follow, and that's the germplasm deposit. And it's rather different from seeds and tuber. The deposit for asexual issue is a little bit more complicated, so we're verifying where it can be done, technical requirements and costs and all those aspects. We're also developing crop forms for the expected crops. And for this, we have the luxury of following the UPOF guidelines. This is completely new for us. And there's no point in creating a different world here. So we look forward to working much more closely with UPOF and our other member countries and CIOPORA to figure out the most efficient way of doing this. So if you have crops in mind already, I think it will be very helpful to get a list of those crops to us so that we can focus on developing those forms that we know will be sending in applications. Of course, we need to develop notices and instructions to our stakeholders and customers. From now on, I'll switch to some questions that were raised by CIOPORA. Those were very, very useful questions, and they happen to be the ones that came up too in our discussions with the various stakeholders. So how will DUS examinations be conducted? We anticipate and envision a similar system to our current examination system. We are a breeder trial system in the sense that current system is the breeders will do the trial and they will do the observation, the calculation, all the record keeping, and then they will submit the information to our office. We compare against our own database. Basically, our own system has all the varieties that have been granted and also the non-PVP types that we know exist. But because this is a new system, it means we don't have a database. That's why we are depending on other countries' systems, the UPOF database, the CPVO, and all other systems. So we still will do the breeder trial, but we're not exactly sure how things will actually work out. If we may decide that maybe we'll go on site to visit and observe, but that would be purely for learning process. We do not anticipate that we will ever conduct our own examination. That's just grow out. That's just too resource intensive. So we will depend on you breeders to do your own. And the same with the US, of course, we will also be verifying the variety denomination. We generally do that already through the UPOF systems and checking with other countries, and also the seed regulatory and testing division keeps a database of all the variety names in the US. The second question, will the US accept DUS reports from other countries? Yes, absolutely. I think that since other countries have a much longer tradition than we do here, it will be very efficient, and probably a lot of the varieties have already been grown in the trial. So absolutely we will accept the DUS reports from UPOF member states that are acknowledged authorities on the varieties. And so in placement of the Exhibit C form, we will accept the US reports. And there are other exhibits, of course, you still have to complete, which the A, B, D, E, that deal with other requirements, reading history, and all those other information you still have to do, but generally the Exhibit C can be replaced by other countries' reports. Another very interesting question. Will the right to save seed crop exemption be applied to asexually propagated crops? I thank you for raising the question, because this quickly became the lawyers in the US breeding community. They quickly raised this issue because their interpretation was that no, because we did not change the seed definition, definitely the exemption does not apply. So there was a lot of internal discussion, and we also sought our legal opinion, and the Office of the General Counsel rendered the opinion that no, it does not apply, because the law was not changed in the definition. So clearly, the current definition of the exemption applies only to seed and tuber propagated varieties. So that's the answer for that one. Just a little bit more information about the deposit. We have decided to require, of course, this will go through public comments, but currently we think that a deposit will be required. And we have worked with the Bigelow Laboratory in East Boothbay, Maine, to check out the capacity, all the technical issues, and they are able to satisfy most varieties, and so that will be the designated laboratory. I forgot to put contact information here, but I will send you our information so that if there are questions, concerns, you can send to those. So that would be the U.S. plan. I guess I will entertain questions.
Dr. Guo, that was very informative, very positive also. It answers several of the questions which we had already in advance and which we placed to your desk, and you were kind enough to answer them in a very positive way. I'm still not fully sure what we think about the depository requirement. It is not very well known in the UPOF system, as far as I know, for asexually reproduced crops, but we will give written comments to it when the regulation is open. Now I would like to ask the auditorium to ask, for sure you have a lot of questions, because this is a very important topic, and you may need more clarification on some aspects. Floor is open, please.